And good morning and welcome to all of you. Thank you for joining us this morning. We're going to have a webinar this morning on an employer's guide to COVID-related return to work issues. Businesses are slowly reopening, bringing employees back across the state of Maine. With that comes a host of challenges. We had a lot of requests for a program like this, so we're really glad to be able to present it to you all this morning. I want to begin by thanking our sponsors. That is Bangor Savings Bank, Central Maine Power, and the Maine Department of Economic and Community Development. This morning, our program is presented by Rudman and Winchell, and we're extremely pleased that they're willing to partner with us on it. So the attendees all know you're muted this morning, and you will not be able to take yourself off mute. But we do want your participation. The easiest thing we've found as we've done these webinars is to have people put their questions into the chat button or bubble at the bottom of the screen. And so as we go along, we talked a little bit before folks came into the webinar, that if you have questions, go ahead and throw them in there, and we will break up the presentation and try and ask the questions as we go along get than all of them at the end. That's going to be our plan this morning. So I want to get our presenter here this morning. It's Anne-Marie Story, who's a partner in Rudman Winchell. Anne-Marie and I have had the pleasure of doing a number of different programs in the Bangor area, in particular, at the end of the last legislative session. She practices employment law, including general advising of employers, litigation, administrative actions. She does trainings and workers' compensation law, and she is a frequent speaker to HR professionals and other groups in the state of Maine. She serves as a member of the, she's a past president of the Maine Bar Association. She's a member of the Maine Board of Overseers of the Bar Professional Ethics. She was born in New York. She's a graduate of Middlebury College. After she was in the Peace Corps, she graduated from Vermont Law School. And so we're very pleased to have Anne-Marie with us this morning. I think you'll find this program informative and helpful. And with that, I'm going to hand it off to Anne-Marie.
Good morning, everybody. So thank you, Peter. And as Peter said, this is primarily for your benefit as attendees. And so we're happy to take your questions at any time. Send them in. We'll address them as they come. Until the questions start coming, what I thought I would do is start with a general overview of a return to a lot of the issues that we're seeing now in the return to work phase. This sort of tragedy has gone from the phase of trying to figure out what the leave laws and the unemployment all mean to everybody to now transitioning back to how do we figure out whether we're going to bring people back, and if we're going to bring people back, how do we do that correctly? So that's what I'm going to start with, but of course we're happy to answer questions about anything you might have. So what I have been concentrating on in terms of return to work primarily is encouraging employers very strongly to become aware of and understand the guidances and the rules that are being issued by the CDC, by OSHA, and by the Maine Department of Labor, because those are your very best guidances on what you should and should not be doing. And in the event you were to face a claim that you had not done something appropriately and perhaps violated OSHA's general duty clause, your best defense to that is going to be able to show that you were aware of the recommended guidelines, you assess the recommended guidelines, and you apply them to your business in the best possible way. Those, whatever the way in which you decide to apply them, should be in writing. It should be communicated to your employees in some way that is clear, that is sent to everybody, and that you recognize this is a fluid plan and a fluid document. So as you bring people back or choose not to, things about your plan may change, and you may realize that you forgot to address certain aspects of coming back in or whatever needs to be redone, and you should not hesitate to do that. So I think the first step you might want to take is to, number one, be sure that to the extent you are bringing people back in the office now, You have printed off all of the recommended guidance posters. So those are all the things on OSHA and the CDC about washing your hands and wearing a face mask and how to use equipment and how to clean things before and after you use them. Those are on their websites. They are free to anybody. They don't have to be fancy. They don't have to be laminated. They don't have to be in color. It's a lot like the posters that are required under state and federal law that you get from the DOL. You can just print these, and you should have them throughout your work site. And if you have people working elsewhere, you're going to want to make them available on social media or your internet or whatever it is you do, however you convey information to people. You also want to be sure that you are keeping updated in the event that those things change or are altered, that you're on top of whatever they are. A next recommended step is to determine what the status is of your work site. So for instance, even in my own office, we started on the top floor and we walked around and around all the way down, looking at different areas of the office, looking at ways in which we could comply with CDC recommendations in terms of social distancing, in terms of addressing how copiers were going to be used without using hands so much, using stylists, taking chairs out of the reception area so that people were further apart, removing magazines, going through the kitchen and taking out anything that people might use constantly, replacing it with temporary stuff, plastic, silverware and things like that. Reception areas, making sure there's the clear screen up so that people coming in have a social distance from the receptionist, not handing out coffee and tea. All of those things are very clearly detailed in the CDC guidelines and are really one of your very first steps to deal with. And that includes things like, do hallways have to be one way or can they be both ways? Do I need to limit access to the elevator? Do I need to find a new way for clients or customers to come into my business that that helps promote social distancing? So those are some very important things to do. And then it's incredibly important that you have written safety protocols, and I mentioned this a second ago, that you detail and that you hand out to employees. Not only is this to make people understand that you are addressing the situation and that you are aware of it and that you are doing whatever you can to make them safe, it is to cover yourself in the event that OSHA or somebody were to come back and say, you have been accused of not promoting a safe work site. How are you going to defend yourself? What are you going to show me to show that you did what you could do? Once you have, and those plans need to be in place before people come back. But as I mentioned, they're going to change as people, as people come in and things go along. Once that plan is done and you're ready to move on, you have to address some of the bigger issues about practicality of bringing people back. So number one consideration might be, are you going to take temperatures? Are you going to test people when they come back into the building? And there are a lot of considerations about that. I know I've got clients who are saying, absolutely we are. I've got other people saying, there's no way I want to be a part of this. So from a legal perspective, probably, when you think about taking somebody's temperature, a red flag ought to go up, because before this situation, that would have been an absolutely prohibited act under the, pretty much every law that exists, and you are not permitted to do it because it constitutes a medical examination. But the rules are different now, and the EEOC and the CDC have been very clear that you are permitted to take temperatures if you choose to do that. But this is something you need to think through. This is not a decision to take lightly. If you are going to take temperatures, you have to determine, number one, who's going to do it, because an immediate supervisor shouldn't be doing it. Arguably, unless the HR person has some medical training, maybe they shouldn't be doing it. So you need to figure out who that person is. Number two, what are you going to do with the information? Are you going to keep it in written form, or are you just going to say, oh, you pass and you can come in? And if you keep it in written form, where are you going to put it? Because this is confidential medical information. So you must have a process by which that information is kept locked up and confidential, just like any other medical information. The third thing is, what are the parameters going to be? So where are you going to set the cutoff for what's okay to come in? And the reason I say that is because what's considered a normal adult temperature is not the same thing as the recommendation from the CDC, which right now I believe is 100.4. So you have to determine, am I going to use the CDC cutoff, or am I going to use what's considered the normal 98 point whatever it is? And then you have to figure out, when I have that information, what do I do with it? So if somebody does test over whatever the threshold is that I set, what is my process from there? And you need to know, because you're going to have to treat everybody consistently. Now, I've had a lot of people say, I do not want to be involved in temperature taking. I don't want that information. And so I'm just going to not do anything. And I'm not sure that that's the right step either, because I don't think that that is probably enough to show the CDC that you made every best effort. I think a compromise could, and there's two ways to do this. Number one is you simply ask your employees a series of questions to represent to you that they have taken their temperature on their own and that it does not exceed a certain number. And also that they have not exhibited any signs or symptoms of COVID. So, you know, there are some detailed questions that you can ask. You know, have you had a cough? Have you have a fever? Do you feel whatever, lightheaded, whatever the other symptoms are? I'm a little bit leery of that, because those symptoms could be indicative of a whole lot of other things. And that could be considered confidential medical information that you probably ought not have. So if you consider that they have not had the recognized symptoms of COVID and do not have a temperature, then you can use that to pass them through. The other way to do this is that there are apparently several apps out there where people can log on and fill in this information on their own. So they're basically asked the same thing I just proposed, but they have to do it in this app form, which puts it into your system somehow so it's in writing, which is always a good idea. I'm not familiar with those apps, so I can't promote one or the other, but that's certainly something you might want to look into. The other thing to consider that I should have mentioned about taking temperatures when people come in is that you have to decide, how long is this going to take as people, are coming into my business? Because if it takes more than a de minimis amount of time, you probably are looking at paying people while they're waiting for you to pass them through whatever this testing process is. So be aware of that as well. So the next really big issue, I think, and this is going to get a lot of attention, as you start to call people back, this is another reason why I think employers need to be certain that they have a plan. And the reason for that is because the order in which you call people back could very well create a discrimination claim for you. So we know that the CDC has identified certain segments of the population that are more prone to exposure or getting COVID. And those include people over 65, pregnant people, and then people with a whole list of potential underlying conditions. So what you're not permitted to do is to take those things into consideration when you're deciding whether to bring people back. So I can't say, well, Sally, you're 67 years old and the CDC says that puts you at a higher risk and therefore I'm not bringing you back. So that's going to violate the ADEA and who knows what else. The same thing is true with medical conditions. This is also not the right time, in my view, to sort of call out people that have been minor problems, but you haven't addressed any performance-related issues, especially if those people fall into some protected category or have had a workers' comp claim or have any other reason to think that you're not calling them back for a valid reason. What I think you need to do is work, and I'm not in any way saying you got to call everybody back at the same time, because I think almost everybody agrees that's probably not the best way to approach this. But what I do think you need to do is come up with a system based on objective factors. So maybe, for instance, I'm going to start with the accounting department because that's my most important department. And so I'm going to call all of those people back first, but maybe not all of my secretarial staff yet because I don't need them. That's an objective way to evaluate who comes back. Now, within each of those categories, you also have to decide, am I calling everybody back? And if I'm not, if I have 5 people in a department and I only want 2 to start, that's okay, but you've got to do an analysis about why the 2 that you choose and not the other 3. And that could be based on seniority, it could be based on skill level, it could be based on the ability to have translatable skills so that one person could do more than one thing. Whatever the factor is, it has to be objective and it has to be applied evenly, because this is not where you want to trip up and get potential discrimination claims. And that includes, and I have had a lot of people say to me in the last couple of weeks, this seems like a good time to not bring back so-and-so. And so what I'm going to do is I'm going to restructure. And so the job that that person was doing is not going to exist anymore. And my response consistently is, if you have a need to restructure your business because of COVID, that's perfectly acceptable. But you need to show that it's about the restructuring and not about the person that you don't want to come back. And the worst possible thing that could happen is that you give this reason about restructuring, and then the next thing you know, you've changed your mind a month later and the position now exists again and you're not calling that person back to it. You're almost guaranteed a discrimination claim at that point. So you have to be very careful about how you do this and do it in a legitimate way. If you've got somebody who shouldn't come back because you've discovered while they were out that there were bad performance things that you never knew about, or something has come to your attention that you didn't know before, you can certainly address that as a disciplinary issue, but you got to be upfront about what the reason is and why you're doing it. So those are just a few factors about how to bring people back and when. Now, what happens if you come up with these great plans and you say, oh, Anne-Marie, I did everything you said I should do. I created a back to work plan. I assessed my workplace. I got it all ready. I picked my people to come back. And lo and behold, nobody wants to come back, right? Because now they're happy teleworking, or they're afraid to come back, or they tell you they have a medical condition, they don't want to come back, or they're caring for somebody who potentially could be at risk and they're not coming back for that reason. That's going to happen, and it's already happening. It's happening a lot. And my best advice is you take those situations one at a time, you deal with them as consistently as you can, and you think through, what are all the things that I need to worry about with this particular issue? Because some of these reasons could involve the ADA, the regular FMLA. So, because don't forget that even if a person may not be eligible for the emergency FMLA under the FFCRA, or they've already used it up, they could still be a person who's eligible for regular FMLA because that's still out there. And then there are a variety of other leave laws that could potentially apply too. So you're going to have to take each situation as it comes. Now, I can address a few potential things that we have been hearing about a lot, just because I'm assuming you've either dealt with them or you're going to. So let's start with a person that you decide to call back and they say, I don't want to come back. I just flat out don't want to. I'm happy teleworking or being on leave. I'm afraid to be out in the workforce. I don't know where this is going to go. I'm just not comfortable and I'm not going to do it. So in working through some of the leave laws, if that's the only reason, there's no medical situation, there's no claim that they're caring for somebody at home who's in a medical situation, there's no child care issue, that scenario all by itself may not lead to any qualifying leave time, in which case you will have to decide, are you going to put that person in a position of being forced to come back when they don't want to, or are you going to permit unpaid administrative leave in those situations? And this is a very, very important decision for you to make, because what they continue to do unless there's a reason to deviate from that, because you've got to treat people consistently. The DOL is encouraging, I think I would say, employers to try to be flexible in these kinds of situations, recognizing that not everybody is going to be comfortable coming back. So if you've got a person who has teleworked consistently and done an okay job at it, it's you know, certainly I think the DOL would say it's reasonable to allow them to continue to do that, even though there's no protected leave law that would allow them to be out. Or if they're not teleworking and they just don't feel comfortable, I think the DOL would encourage you to consider a period of unpaid leave. Now, I have one caution about that, though, and that is that I'm not a fan of just saying, okay, you can be on unpaid leave indefinitely and we'll figure out when this whole situation ends, because quite honestly, it doesn't appear as though anybody knows if and when the situation is going to end. And so I don't think you want to be in a position of offering unpaid administrative leave forever. So what I'm recommending in most cases is to put a discrete time frame on it. So either that's based on when the next executive order is scheduled to come out from the governor, or you know, you just pick sort of the end of the next month or whatever it is, and you say to that person, you know, I'm gonna allow the leave through this time period, and when we get to that day, we'll reassess the situation and see what's happening. Because it may be that you can't leave people out indefinitely. I mean, if you could, you probably wouldn't need them in the first place. So you want to be careful about just giving a broad stroke like that. So the next possible situation is somebody says to you, I'm not sick, but I have people at home who also are not sick, but they are at risk, at an increased risk. So they're either elderly, or they have one of those underlying conditions that the CDC says could be more easily aggravated. And again, you know, you start with the same assessment. So your employee has said that they do not have a medical condition, so that strikes that out. The person at home does not appear to have a medical condition yet. It's just a fear of developing one. So then you have to decide, is this a request for reasonable accommodation under the ADA? Well, it's not, because it's not the employee, it's the employee's relative or whoever lives with them. If that person is not already sick and the employee is not needed to care for them, then the FMLA probably does not apply either. And so then you go through the factors of the FFCRA if they haven't already used it up, and if that doesn't apply, then you're pretty much back to the same assessment we just made with an employee who just doesn't want to come back. And that is, can they telework, and are you willing to let them do that? Or if not, are you willing to give a period of unpaid time? So the biggest, the piece here that's gotten the most press, of course, is what happens when it's the employee themselves who is currently not sick, but is in one of those more dangerous categories. And so the question then becomes, is that a request for reasonable accommodation? And the general prevailing sense seems to be that if they've got this underlying condition that could potentially be significantly compromised by COVID, that may well be a request for reasonable accommodation, and you probably would be best off assessing it as such. So then you go through essentially what turns out to be the same analysis, and that is, how do I provide a reasonable accommodation to someone who can't be in the office? Can they telework? If they can't telework, can they, am I willing to give them a period of unpaid leave? And again, for certain periods of time, after which you would want the doctor to continue to certify they need to be out. Now, something about the teleworking, and I know this has come up for several people, and that is that a lot of times teleworking is requested as a form of reasonable accommodation, even without regard to COVID. Even before COVID, people have asked to work from home as a reasonable accommodation. And a lot of times employers are hesitant to allow that because, I mean, for most people, the idea is that you're in the place of employment and you're there to interact with people and you're needed to be there. And so a lot of times those are turned down as requests for reasonable accommodation. So the DOL has addressed, or the EEOC has addressed this recently, because what the suggestion is that if that is now made as a request for a reasonable accommodation, even if you had turned it down before COVID, you have to reassess it, and you have to be able to show that you reassessed it for somebody who has been out in the meantime teleworking. Because essentially what the EEOC is saying is, you might have thought that this wasn't a reasonable accommodation before, but now these extreme circumstances have caused that person to telework and you've permitted it. And if it's worked out okay, then lo and behold, maybe this is a reasonable accommodation and maybe you need to reevaluate the denial of that in the first place. So that's something that you'll need to take into consideration. So Peter, just to sort of check in, I've been flying through this stuff. Are we have questions to address, or should I just keep going?
I do not have any questions as of yet. I guess the question is, and we had a conversation about this before we started, if you haven't, are you planning on touching the issue with regard to school closings and daycare closings? I
am. My two big things to be sure we address are masks and all the things that go along with it, and the whole child care thing. And I can do that now because we've had quite a few questions recently, which says to me that people are starting to bring people back. And now there's these issues about what do I do with my child who is at home now because school is out. So as you know, the FFCRA and in both aspects of it provide the leave for an employee, and the language is
Hey, Anne Marie.
I'm sorry.
Yeah, I did get one question. It says,
okay.
It states that before we go on to the schools, if a person states they do not want to come back due to a direct family member being in a high risk group, can I ask them to resign?
So I would start with not initially, no. I think that you are charged with going through the analysis that we just did, which is, I think the better course of action is to show that you at least attempted to work through permitting them to do what they needed to do. So the first step is to be sure that your employee is not covered by the FFCRA, because that does cover caring for an individual who is subject to quarantine or an isolation order. So if that person at risk has been told by their doctor, you must isolate, then you don't want to run afoul of the FFCRA by not allowing that leave. And that's not the emergency FMLA, because that's just kids, but at least the 80 hours. So there's that piece of it. And then the next piece of it, is just in terms of reasonableness. I know that they wouldn't be covered by the ADA because it's not the employee themselves, but it would probably behoove an employer to at least attempt to make a temporary attempt to allow somebody to at least telework or maybe have some leave. But yeah, in the long, you will reach a point where I agree it's not reasonable to allow somebody to be out just because they've got somebody at home who is high risk. I think the real the question is where is that line? And so you want to appear reasonable and that you tried to work with somebody to give them as much time as possible, but yet you recognizing that you need people back. So I think it's going to depend on the situation. It's going to depend on whether somebody can reasonably telework or whether you legitimately need that person to be back in the office, and probably other factors like that.
I've got one more before you jump. What are the current guidelines for employees traveling together to work sites and personal vehicles, and about commercial vehicles, and can we find them in writing?
I would direct you to the CDC website because they have guidances based on type of employment, type of work. And so if that's, for instance, a construction company, there are guidances specific to construction companies. So that's the first place I would look, because it may very well tell you what to do. If there is no specific guidance, then I think you fall back on following the general CDC guidelines. And if you can't, so then you have to assess things like, They obviously can't be 6 feet apart if they're in a truck cab. And so I would at the very least, require wearing masks at any time when they're in proximity to each other. But you may have to look toward other options as well, like having each person take a separate vehicle so that they're distancing while they're doing that. It's all about creativity. All right. Okay, so just to address this issue with children, so you know that both the emergency paid sick leave and the emergency FMLA cover caring for a son or daughter if the school or child care provider is closed. So we've dealt with a lot of questions about this recently because schools are now closed, not because of COVID, but because of summer. So if that's the only reason that a child is not in school right now, and it has nothing to do with COVID, then arguably the employee is not entitled to the leave under the FFCRA unless you have a regular child care provider who is also closed due to COVID. Now, we've had a lot of discussions in the last couple of days about what does that mean in the summertime. Let's say the normal child care provider that I use is not closed and they have opened back up, but I'm not comfortable sending my child there just because of the situation. And I think we have a consensus so far that that is arguably not covered by the FFCRA because it says closed. However, I don't think an employer, I had this question the other day, and I don't think you want to be in a position of saying to somebody, well, that one might be closed, but I'm not going to give you the leave because there are 5 camps that I know of that are currently open and you could use one of those. I do not think that's an appropriate approach to this. I think if the employee's regular child care provider is closed, they are entitled to the leave. If the child care provider is not closed, but the employee doesn't feel comfortable sending the person there, then that's to me the more gray area. But I don't also think that should result in an immediate termination. I think, once again, you should try to work out an arrangement with an employee. So either they're teleworking or maybe taking a short burst of unpaid leave time until you absolutely need them back in the workforce and things haven't changed and they say, I'm just not coming in, at which point you may be able to terminate. But I think those are, again, like everything else here, those are some very gray areas. But that's what the child care situation seems to be for right now. Were there any other questions? I assume there are no other questions about that, or if there are, you can let me know, Peter, and if not,
there's one that just popped up that says, what about grandparents who provide childcare?
Well, so again, you go back to what the rule is, and it says if the unable to work due to a need to care for a son or daughter under the age of 18 if the school or child care provider is closed. So I think that you're going to have to get creative with that response. If the grandparents are okay and able to continue to provide the care, then I don't think the employee is entitled to the leave. But if the grandparents are isolating themselves because of a fear of COVID or whatever the situation might be, as long as it's related to COVID, then I think the employee has an argument that their regular child care provider is not available due to COVID, and they probably would be entitled to that leave. I think if you were to ask somebody, if you were to ask the DOL or the EEOC, I think the general response would be to look at these maybe with more flexibility than we have used in the past for requests for leave and interpretation of the FMLA and whatnot, partially because the law is still, there are some gray areas in it, and partially just because of the situation that everybody's trying to deal with. Probably never thought you'd hear me say that, but okay, so I mean, if other questions come up, we can take them as they come, but I did want to talk about masks. So I've had more questions about masks in the last 2 weeks than I ever thought were possible, but they're kind of fun too. So here's the issue with masks. right now, you have to look at the governor's orders. And again, I mentioned that there are guidelines under the I think they're on that. They have of what all of these recommendations are for based on each kind of business. So that's the first place that you should start, because some employers are going to be required to require people to wear masks, but others are not necessarily. It's just encouraging people to wear masks. So you have to decide where you fit in those categories. If you are an employer who is not required to have people masked, you will see from the guidelines that it is encouraged. Especially where social distancing is not always possible. So at least I have found is that, you forget how people congregate in a workplace, at the copier, at the microwave, in the kitchen, in the bathrooms, and 6 feet of space is often not possible. So I think masks are probably recommended anytime someone's out around other folks. Now, issues with masks, number one is the CDC has been clear, at least so far, and when I say masks, I'm not talking about the masks in a healthcare setting that are actual, real, functioning masks. I'm talking about the cloth masks that everybody wears for social distancing issues. These are not considered PPE, personal protective equipment, by the CDC. What that means is you as the employer are not responsible to provide them, and you're not responsible to maintain them, which is not to say that you can't do either. You certainly can have boxes of those, the standard masks that you can now find in all the stores available to people. And it's not a bad idea to do that just in case somebody forgets theirs or, leaves it in the car or whatever. If you allow people to have their own masks, you always think, I shouldn't have to say things like this to adults, but the fact is that we do. You have to have some sort of, be prepared to address the professionalism of the masks. And again, it's surprising that we even have to say this, but you need to decide what's okay in your workplace, because I personally have seen masks out in the community that are completely inappropriate for anything that would come in the workplace and probably violate harassment guidelines. And also there are masks that have all kinds of great designs on them. My daughter has a ton that are fun and happy, but you have to decide, is that what I want in my own workplace? Is that professional enough to have here? So that's a consideration. And then the question is, are you going to maintain them as the employer, or are you going to charge the employee with that? Now, you most certainly are going to have somebody say, I don't want to wear a mask. So the evaluation for that is, it goes in either one of two directions. If it's a personal preference and there is no medical or religious or other reason based on a protected category that somebody does not want to wear a mask, it's just, I don't like them, I don't want to wear it, then you can enforce the wearing of the mask like any other performance-related rule. So now it becomes a conduct rule. And you can require people to wear it if that's what your rule is. But again, make certain that you are enforcing this consistently. So don't let one person get away with not wearing it when you're requiring somebody else to wear it. If, however, the employee says, I don't want to wear it because I have asthma or I have some other condition, medical condition, that makes it difficult for me to wear, or my doctor has said I cannot wear a mask, that is considered to be a request for reasonable accommodation, most likely, and you need to work from there. So you can't just require somebody to wear it. You have to go through that analysis and figure out, do you have a qualifying disability? And you can ask for confirmation from a doctor of a disability, and also what they need as a reasonable accommodation, meaning they need to not wear the mask. At that point, you have to figure out how you can accommodate them. So you either can work with them to see if there's a different kind of face shield they can wear, like the ones that are plastic and come down in front of your face, but aren't cloth against your mouth. So that might be something that you can have them wear. Or if you can have them work in a place that's totally isolated from everybody else, that might be a different kind of accommodation. So whatever it is, you just need to put the attention and effort into working through it. You may also get a question about whether or not somebody can wear a mask if they have a religious objection to doing so. And so if that happens, you would evaluate it just like you would any other request for a religious accommodation, recognizing that the undue burden standard under religious accommodation is lower than it is under a disability. But again, you need to work through what the reason is, why specifically they can't wear it, and whether or not there are alternatives that you can come up with. Are there any?
I've got a couple of questions on the mask issue, and we've got a couple of other questions too, which we can come back to.
Sure, yeah, go ahead.
Specifically around the masks. Are there requirements, cleaning, donning, duffing, etc., on using masks if employees are only encouraged to wear them?
I don't think there's any obligation on the part of an employer to clean or maintain a mask that an employee is not required to wear or that is not considered to be PPE.
Okay. The other question appears, and it's a statement, but for those employees that don't want to wear a mask or say they have a reason why they can't wear a mask, how about using a face shield?
I think that's perfectly appropriate as long as the CDC says that that's equally as effective as a mask. And I don't know that to be true, but I see people wearing those all the time. So I assume that it might be, but again, I would refer the employer right back to the CDC and look at what their recommendations are.
Okay, let's go back if you're okay, and we'll ask a couple of these questions that have come up. Does an employer have any legal standing to require staff to get a COVID test before coming back to work? Example, staff exhibited COVID symptoms while home and business was closed, or staff was in contact with someone who was known to have COVID-19.
Again, I would refer that person back to the CDC guidelines for whatever they are currently saying. I know at one point they were definitely saying if somebody has been potentially exposed to another person who had COVID, an employer can ask for either a quarantine period or a negative test before they come back. I don't think that's a recommended procedure, just if people have been out without any particular exposure or other reason to think that they might have it or have been exposed to it.
Once an employee on FFCRA or EFML exhausts the leave or meets the financial ceiling, does the employer have additional requirements under FMLA?
Well, I think it depends on what the condition is. So once they've exhausted the expansion, the first question is there any leave left? Because don't forget that the total leave is the 12 weeks. So if they've already used 12 weeks between the emergency leave and the emergency FMLA, then they're not going to be entitled to any more regular FMLA until however your year is calculated. So either based on the rolling year or the calendar year. But if they haven't used all of their leave time and they do have time left, then you would assess it just like you would any other request for a possible FMLA and go through the procedure to figure out whether they meet the qualifying conditions. And don't forget the ADA might apply too, because reasonable accommodation always includes potential for additional leave time even after the FMLA is exhausted. So if it's a qualifying disability, there may be a need to provide that additional accommodation as well.
One office has indicated they've moved to one-way traffic throughout their office to avoid too much contact. Is that over the top or is that appropriate?
I don't think it's over the top, and in fact, it's one of the things that the CDC mentions. And of course, you'll see, all the grocery stores and box stores and whatnot have done that as well. So I think it depends entirely on your workplace, but if you're able to do that and it promotes social distancing, I would, my perspective is that the CDC would encourage that.
Back to a mask question. What happens if you're the owner of a building that houses businesses in separate offices but with common areas? Several tenants are not following the rule to wear masks in common areas, and we're wondering what we can legally do to enforce the rules.
Well, so that's a trick question because those are not employees. And so now you're talking about, sounds to me like you're talking about landlord-tenant issues, which I can't speak to what the public accommodation rules are outside of the employment relationship.
Yep. What if the employee says they cannot even wear a face shield due to a medical condition? I think this goes back to what you said earlier.
Yeah, I think you can ask for reasonable documentation from the physician about what the reason is that they can't wear whatever it is on their face, so that you have a better basis to determine if there is a different form of accommodation. But if, let's say you get a note from a doctor saying this person can't have anything on their head at all, then I think you don't give up. You continue the interactive process, and you have to determine, is there any other way for me to accommodate this person? So if let's say they're working in an office where we can close the door and they're never going to interact with other people, that might be something reasonable. Or can they telework, which would solve the problem as well. So, and if there isn't another way, then you have to decide, do I allow them to take a period of unpaid leave to see if this works itself out before we terminate, or do we go to termination? And that will be very dependent on the situation.
That's it for our questions, if you want to jump back into the presentation.
Okay, so I see we have about 8 or 9 minutes left. So
about 10 minutes.
Let me just hit some random thoughts here. One of the things that I've been thinking through, and of course I'm, paranoid lawyer stays up all night thinking about things that might never happen, but I want you to be prepared in case they do. And so we haven't talked about workers' comp, so that's out there. And then before I get to that though, let me just touch on this issue about performance evaluations, because I've had employers say, well, now I've had somebody out for 3 months, how am I going to do a performance evaluation? So actually the EEOC has sort of weighed into this, and there have been some suggestion that employers take into consideration the fact that people have been working under extreme circumstances, and especially for people who have been telecommuting or who aren't accustomed to doing that, maybe aren't able to do all the functions of their job or have had a lot of problems with their computers. That you take all that into consideration either in the review itself, or you just put them on hold and you wait until things get back to whatever the normal is going to be, and then you reevaluate, maybe even give them a whole new performance evaluation year. Or the other alternative is to just evaluate based on the period of time up to when all of this happened. So just to be sure that you're being fair to everybody, regardless of how they were affected by the situation. And so I guess what let's do is maybe just touch on comp, because I don't, when this first started, everybody was really worried that we were going to get this avalanche of claims and that it was going to cause havoc in the system. And that really hasn't happened. Obviously there have been claims, people have gotten it and contend that it is work related. I think for the most part, it's dependent at this point entirely on what kind of circumstances in which you work. So healthcare situations are probably different than a regular office setting, especially when people haven't been back very much. But for the most part, until we're advised differently about a new presumption or changes to the law, the way to assess these claims is just like any other claim, which is that it's the employee's burden to prove that whatever the condition is, it arose out of and in the course of employment and not in some other setting. And so it's their burden to show that they got it because they were at work, as opposed to being at the grocery store or childcare or wherever else they might have been. The other thing to consider, though, is that there are other ways in which comp can come up in these situations, one of which is stress. And I have seen a few of these cases so far, either that somebody is so stressed out by being back in the workplace and not wanting to be there, or by having to work from home and not understanding the system and having to learn all this new stuff. And So again, you evaluate those based on what the law says, whether it's a stress claim or a physical claim or a mental or mental physical. And then the other situation is, in the event we ever do develop a vaccination or an inoculation, we're not there yet, but people ought to know this is very similar to the flu situation. If an employer ever were to require something like that to be done, then you would essentially buy any negative results of that under workers' comp, unless the law changes because of it. And of course, that's all speculation at this point. But it's something to be careful about. You want to pay attention to what people say and make sure, if they're raising a potential claim under stress or whatever, that you're responding appropriately and letting your carrier know.
We did have another question regarding COVID-19 symptoms in the workplace. While they're at work, are you allowed to remove that employee from the website? From the website, excuse me.
Delete them from the website. Yeah, I mean, again, I would check the CDC, whatever the updated guidelines are, but my understanding is that if somebody is there and exhibits the known symptoms of COVID, you can require that they leave and either self-quarantine, or now that the tests are more readily available, that might be a better option, is just to go and get a test. And be aware, and you mentioned this earlier, Peter, and I did want to bring this up. If something like that were to happen, now that people are coming back, or there are new issues with childcare, and somebody has not yet utilized any of the FFCRA or all of what they're entitled to, they could be entitled to use the rest of it or to start it now, because as we mentioned, a lot of people started this immediately upon when it became effective, but it runs all the way through the end of the year. So December 31st, or the 31 days in whatever, however many days there are in December. And then it runs out then. So they have between now and then to use it if they haven't already used it. And that might be a situation where that would apply.
That appears to be the end of our questions at this point, unless someone right back in. Do you have anything more you want to add? I mean, we could speculate a little bit for folks who are on the call. I mean, Anne-Marie and I talked a little bit about what the next legislative session looked like and what I see over the horizon for bills. I think there will be a lot associated with COVID. I don't know whether there'll be anything in the special session slot that may be coming along. I think that, as other states have done, I think Maine will take a serious look at whether they put a rebuttable presumption in for workers' comp benefits associated with a COVID-19 case. I think that there certainly will be one for first responders, whether that's extended to any essential healthcare personnel, any essential workers, healthcare, grocery stores, etc. I just don't know yet. There have been, I think, Anne-Marie, you agree, there have been some expansive ones in some states, correct?
Yes, there have. Quite a few states.
I think there will be issues with leave, associated with leave, creating more leave, making it easier for workers to access leave, whether that's paid or unpaid. And I think there will be liability issues as well. I mean, some folks are pushing, in other states, there's been successful sort of safe harbor legislation for employers who are reopening when it comes to liability in COVID-19. In other places, there have been attempts and successful attempts to limit the employer's ability to shield themselves from liability protections. So I think we'll have both of those bills in the upcoming legislative session. I don't know if you want to add anything around liability or not. You know.
I do want to just say one thing, because I've had employers ask me to do this, and I want to be clear that you are not permitted to ask somebody to sign a release to waive away potential workers' comp rights in the event they contract COVID in the workplace. It's a crime. You can't do it. But I know a lot of employers have felt like, I want to protect myself as much as I can, and they don't realize that that's not okay. But so please don't do that.
No, that is a bad idea, and you can't do it anyway. You can't do it. Well, I think that pretty much wraps up our presentation for this morning. We've had a great crowd. People have hung on. We've had good questions. I want to thank everybody for participating this morning. I want to thank our sponsors, Bangor Savings Bank, Central Maine Power, and Maine Department of Economic and Community Development. I want to thank Anne Marie and the folks at Rudman Winchell for partnering with us on this. As we indicated to you earlier, this was recorded and it will be up on our website in the next few days, so folks can access this presentation again if you want to listen to it. Thank you very much. Stay tuned. We're working on more webinars like this for folks. A lot of uncertainty out there. Employers are looking for answers. We're trying to help them with the best and most timely and accurate information that we can provide. So thank you all very much and have a great week. Stay safe and